Hello and welcome to another episode of THP Tutorials. In today's video, we are going to continue with our series on company and partnership law. This is the fourth chapter, and this chapter is talking about the capacity of a company. So, for the outline of this chapter, we will first define what the capacity of a company means, and we also talk about other things and other ideas or concepts that come up when we talk about the capacity of a company. We also look at the principle known as the ultra vires principle, and lastly we will discuss the veil of a corporate entity. Right, so what is the meaning of the capacity of a company? Right, the legal capacity of a company may be defined as the things that the company is entitled to do or not to do for the purpose of carrying on its authorized business or pursuing its authorized objectives or objects. Now, Section 24 of the Act provides that, except as otherwise stated in its regulations, a company incorporated under the Act has the capacity of a natural person to carry on its authorized business or pursue its goals. Very well. So, to start explaining some things, when we talk about a natural person, under the law there are two types of persons. There's a natural person and there's a legal person. The natural person refers to the normal regular human being that we go and come, right? And the legal person is talking about companies or entities, right? So when you hear a legal person, we're talking about the entity, right? And when we say the capacity of a company, it means that as a natural person, as an adult above the age of 21, that's the age for capacity to contract, right? As a normal human being above the age of 21, all the powers you have, all the business that you are entitled or authorized to carry out or engaged in are the same entitlements or rights or the powers of a company, right? So that's what it means by a company incorporated under the Act has all the capacity of a natural person, right? So whatever a natural person who has the capacity to contract can do, so too a legal entity or a legal person or a company can also do once it has been incorporated under the Act. This means that the capacity of a company is to carry on its authorized business, and the capacity of a company may be limited by its regulations, right? Now, we talked about the company regulations in our previous chapter, so you might want to check that out if you are feeling a bit lost. Now, the Companies Act and the regulations, that is the company's regulations, may impose certain limitations on the capacity of companies, right? When a company exceeds or goes contrary to these limitations, it is said to be ultra vires, right? So now talking about the ultra vires principle. Very well. So we said that the Companies Act and then the regulations of the company, these set the limitations on the capacity of the company, right? These set the limits or the boundaries for the company's authorized business. Section 25 provides that the company shall not undertake a transaction or carry on business not authorized by its regulations or exceed the powers conferred on it by the Act and the regulations of the company, right? So that's what we just said, right? So this is saying that the portion of the Companies Act, which is Section 25, is what spells out the fact that the company is regulated by the Companies Act and the regulations of the company itself, right? And the company should not exceed the powers conferred on it by these two laws or by these two guidelines, if you will. Very well. Now, the company must act within those limits. A company has no legal capacity or power to carry on a business or pursue an object not contained in its regulations, right? So that's what we mean by the ultra vires, right? When a company is said to be ultra vires, it means that it has gone beyond its legal capacity. Ultra vires is a Latin expression which means beyond one's lawful authority. Section 25 of the Companies Act expresses the doctrine of ultra vires. A company shall not undertake a transaction or carry on business not authorized by its regulations or exceed the powers conferred on it by the Act and regulations of the company. Very well. So, why is the ultra vires principle important, right? What's the significance of it? The importance of the ultra vires principle is to protect shareholders and other investors such as creditors, right? In the absence of such limitations, the management of the company may gamble with the resources of the investment made by the shareholders, right? And such conduct may expose the investment of shareholders and other people to unexpected business risks. A company may alter its regulation if it wishes to engage in any business not authorized by the regulations. Similarly, a company may exercise powers not conferred on it by altering the regulations to confer on it such powers, right? So, what do we take away from this? First of all, the purpose of the ultra vires principle is to protect shareholders and investors, right? And this is because the shareholders are the ones who found the company, right? So, it's their money and their resources that was used to found the company. And the company has members or managers who manage the company on behalf of the shareholders. So, the regulations of the company and the Companies Act have set the limits for the company so that the management cannot go about making reckless choices, regarding investments and businesses and end up destroying the investment of the shareholders, right? So the ultra vires principle is meant to protect the shareholders, right? Now, in a situation where the company as a whole, both the shareholders and the members wish to go beyond their current boundaries, they may alter the company regulations to confer on the company itself those limits, right? So maybe you want to go into business B, but the nature of business B is beyond your limits, right? So you can alter the company's regulations to go beyond that limit. So now you can actually engage in business B without you being ultra vires. Now, let's look at the consequences of the ultra vires principle. Where a company acts ultra vires, it may result in losses and the company may incur liabilities. Generally, at law, an ultra vires act is deemed to be void, right? So generally, all ultra vires acts are deemed to be void, right? Now, in law, we say a contract may be void and it may also be voidable. When a contract is void, it means that no contract exists anymore, right? So when a contract is void, it means that basically there is no contract. However, when a contract is voidable, it means that at the option of one of the parties to that contract, so it means that one of the parties to the contract will have the right to render the contract void, right? But until they choose to do so, the contract will still be valid, right? So voidable means that one of the parties will have a choice to say, okay, let's continue in the contract, let's continue doing business. However, that party with that right or that privilege can also decide to say that no more, we are done, and the contract will be void. Well, see, under Ghanaian law, however, an act deemed ultra vires does not by itself, in certain circumstances, render the act invalid or void. Now remember, we said that what generally at law, an ultra vires act is deemed to be void. That's true. However, there are certain circumstances, right? There are certain transactions which, when even though the company is ultra vires, it does not automatically render the that business or that transaction void, right? And two of such situations involved the transfer of property and court intervention, right? So let's talk more on that. Now, instances where the ultra vires acts are not invalid or void Well, so the first is the transfer of property, right? Now, Section 25 provides that no act of a company and no conveyance or transfer of property to or by a company shall be invalid by the reason of the fact that such act, conveyance or transfer was not done or made for the furtherance of any of the authorized businesses of the company, or that the company was otherwise exceeding its objects or powers. Very well. Now, this is to protect third parties who deal with the company without knowledge or means to know that the company is acting ultra-virus, right? Now, this has a lot to do with the internal management rule. We'll touch more on it later in this video, but we covered it in the third chapter, so you can also go and watch that and get a better understanding. Now, let's talk more about the transfer of property exception to the Ultra-Virus Act, right? Now, Section 25 of the Companies Act is saying that no act of a company, right? No act of a company, no conveyance or transfer of property to or by the company shall be invalid by reason of the fact that such act, conveyance or transfer was not done or made for the furtherance of any of the authorized business of the company. This is just saying that, in the interest of the third parties, the people who are dealing with the company without knowing that the company has gone beyond its legal limits, the law, Section 25 of the Companies Act is stating that even though the company has gone beyond its limits and is ultra-virus, that transaction will not be void, right? Because if that transaction is void, it will be unfair to the third parties who were being genuine in their transactions, right? So that's an instance of the ultra-virus principle not rendering a transaction invalid or void. Yes, so for a second instance is court intervention, right? Now, this talks or speaks to what can be done when a company goes beyond its limits, right? Now remember, the shareholders of the company own the company, but they don't run it, right? So in certain instances, court intervention can reverse or nullify the negative effect of an ultra-virus principle, right? So let's look at how that can be done. Very well. Now, the court may, in certain instances, intervene to prevent or remedy ultra-virus transactions, right? So remember, to prevent or remedy ultra-virus transactions, right? So what I'm talking about here is that the company has gone beyond its limits. They have messed up. They've gone beyond their limits, right? And they are ultra-virus. Now, what can be done about it, right? What can be done about it? So let's look at that. Now, upon application of a member or a debenture holder secured by a floating charge, a court may grant 1. An injunction to prohibit ultra-virus transactions. 2. An order to set aside the performance of a contract. 3. Compensation to the company or parties to the contract for loss or damage sustained by setting aside or prohibition of the performance of the contract. Very well. Now, when we say debenture holders, they are merely lenders to the company and are considered to be creditors, right? So these are some of the things that can be done when a company goes beyond its limits, right? So this one in particular is protecting the shareholders, right? Now, what else can be done? Now, the court can also intervene to prevent a threatened breach of duty. What do you mean by a threatened breach of duty, right? Now, threatened breach means any indication, verbal or otherwise, of such shareholders' intention to breach or such shareholders' impending breach of any of the provisions of this section 13, right? So that's what we talk about. So in a situation when a shareholder or a party to a contract is threatening to breach their duty, they can be sent to court, and the court will prevent them from doing so. Right now, the court may also order the recovery of property from the directors of the company. Right, section 217 also entitles a member of a company to apply to the court for an injunction to restrain the company from doing an act or entering into a transaction which is illegal or beyond the power or capacity of the company, and or infringes the regulations of the company, and where any such act or transaction has already been done or entered into, the court may declare it void. Now, when we say an injunction, is a court order, usually one telling someone not to do something, right? So an injunction is a court order that tells someone not to do something, right? Yeah, so the court intervention simply remedies or prevents ultra-various transactions, right? Very well. So now let's take a look at Terquoin's case, right? Now this is about the internal management rule. Royal British Bank, right, versus Terquoin, 1856, right? Now this case is what established the internal management rule, right? Because common law, right, is based on legal judicial precedents anyway. So Terquoin's case is a UK company law case. People transacting with companies are entitled to assume that internal company rules are complied with, even if they are not. This indoor management rule, or the rule in Terquoin's case, is applicable in most of the common law world. This rule seeks to provide a certain measure of protection to third parties who deal with the company vis-a-vis or face-to-face. The rule in Terquoin's case is to the effect that third parties are not required to inquire to ascertain if all internal processes and procedures of the company have been complied with, right? So this internal management rule is to protect genuine third parties, like people who are genuinely dealing with the company. And this law says that such individuals who are genuine in their dealings with the company do not need to verify or do not need to make sure that the company, the company's regulations are being adhered to, right? They are entitled to assume that whoever is dealing with them on the behalf of the company has complied with all and such regulations. This rule has received statutory recognition in Ghana in section 202 Act 6 of the Companies Act, which stipulates that no person dealing with a company in good faith or registering any disposition of or title to property shall be concerned to see whether the conditions in section 202 Act 6 have been fulfilled, and the provisions of sections 139 to 143 of the Companies Act shall apply to any transaction of the type referred to in this section, notwithstanding that such conditions have not been fulfilled, right? So it's the same thing, right? Third parties are entitled to presume or to assume that the company's rules and regulations and have been complied with, right? And the company has followed or is abiding by the Companies Act. Now, disposition in trust and estate law is a transfer, gift, or sale of property from one individual to another. Disposition is generally done through a deed or will and involves transfer of possession, right? So there no person dealing with a company in good faith or registering any disposition. So I think that disposition is the transfer, gift, or sale of property from one person to another. Right now, remember the internal management rule was dealt with in chapter 3, so you can just see that video if you haven't, and you'll be okay. Now to the last part of our video, the field of a corporate entity, right? But before we discuss that, what exactly is a corporate entity? A company, once incorporated by the registration of its regulations and a subsequent issue of a certificate of incorporation, becomes an entity, separate and distinct from its members and directors, right? So the company is a legal person, right? It's not a natural person. So the company is its own person, or in law, companies are treated as if they are people, right? It assumes a separate and artificial legal person status. The fact that the company upon incorporation assumes an independent and separate personality has given rise to the concept of the existence of a corporate veil that stands in between the company and its members and directors, right? So when you say the directors of the company, those are the shareholders, and then the members are the people who are running things in the company, right? Now this view separates the company from its members and directors. In effect, the deeds of the company are its own and not that of the members and directors, right? There are instances where the corporate view is done away with to hold the directors and members personally liable for the acts of the company. In such instances, the corporate view is said to be pierced or lifted, and this can happen under any of the following instances: A. Violation of the Companies Act. 2. B. Violation of the legislature. And C. Decisions of the court, right? So what I'm saying is that even though in normal circumstances the company and its directors and members are different, there are instances when we will ignore that assumption and hold the directors and the members liable for the company's actions. And so let's talk more about the first one: violation of the Companies Act. See, where a company carries on business for more than 6 months without at least one member, the directors become personally liable for all debts incurred by the company during that period, right? So this is saying that as a company, when you carry out a business for more than 6 months, right, 6 months consecutively, right, without at least one member, right, meaning that the member is like the managers, right? So and this is because the directors are the shareholders, then the members are the managers of the company. So if the directors don't run the company, right? It's the managers that run the company or the members. So what he's saying that as a director of the company, if you are to spear on or like go and do business by yourself, at least one member of the company should be there, right? So that, because they are the ones who are running the company, the act is saying that if you continue to do so for more than 6 months, then as a director you are personally liable for all debts incurred by the company during that 6-month period. That's section 38, right? Now, where a company carries on business for more than 4 weeks after the number of its directors fall below 2, there shall be a penal liability, right? When you say penal liability in law, it's a criminal liability, right? And it refers to the legal responsibility for a criminal act, where an individual performing the act can be found guilty and may face penalties such as imprisonment, fines, or both. Default is the failure to fulfill an obligation, especially to repay a loan or appear in a law court. The company will have to restructure its debt to avoid default. So as we were saying that, where a company carries on business for more than 4 weeks after the number of its directors fall below 2, there shall be a penal liability, and any director or member in default shall be liable to a fine, right? So that's what we talk about, penal liability and default. Also, for any debt incurred during that period, the directors and the members shall be jointly and severally liable, right? That means that jointly, that together, and individually, that's the severally. Well, now, where a company fails to file its returns prior to transacting business, right? So as a company, if you fail to file your returns before you are transacting your business, then when you breach the limits of the company, you'll be held personally liable. Well, now when the company breaches its minimum capital requirements, right? Minimum capital requirements is the least amount of capital the company needs to operate. Now the company and every officer in default becomes liable to a fine for each day of the default. The directors and members shall be jointly and severally liable for all debts and liabilities of the company. Where a company limited by a guarantee engages in profit-making activities, right? So if you want to understand this more and why it is wrong for a company limited by guarantee to engage in profit-making activities, then you should check out chapter 2 in this series and you'll be good to go. The other ones are violation of the legislature, right? And that has to do with when the company or when the members and directors of the company commit fraud when you are winding up the business, right? When you are closing down the business and you commit fraud in that time, the business would already be closed down. So the company will be, the directors and the members themselves will be held liable. Aside that, to lift the veil of a company, that can also be done through the decision of a court, right? So a court can decide that the veil will be lifted or pierced, and the directors and the members should be held liable for their actions that they have committed. So that's all for this chapter. Thank you very much for watching. Please don't forget to like and subscribe.